Welcome to Daksh Dialogues. I'm your host, Ritima Singh. I work with Daksh, a think tank working on access to justice and judicial reforms. Today, we are discussing a judgment that has sent ripples through India's insolvency landscape. This is the recent Supreme Court verdict concerning Bhushan Power and Steel. At Daksh, our mission is rooted in understanding and strengthening the foundation of India's legal and governance frameworks. We believe that a robust legal system is paramount for a thriving economy and a just society. Through our research, discussions, and public engagement initiatives like this, we aim to foster informed dialogue and contribute to evidence based policy reforms. This Bhushan Steel judgment is a prime example of a case that demands our collective attention. It challenges our understanding of the Insolvency Bankruptcy Code, IBC, and raises profound questions about judicial oversight and directly impacts the confidence of investors and creditors in India. Starting with a brief overview of this case, Bhushan Steel, once a significant player in steel industry, found itself in deep financial distress, owning above 47,000 crore. In 2017, it became one of the first 12 largest defaulters India identified by Reserve Bank of India, the Dirty Dozen, for a resolution under the nascent Insolvency Bankruptcy Code. The corporate insolvency resolution process, CIRP, and began after a competitive bidding process in which JSW emerged as the successful resolution applicant with a bid of over 19,000 crores. Now, looking at the journey of this case from National Company Law Tribunal, NCLT, in September 2019, the NCLT approved JSW's resolution plan. This was a crucial step signaling the potential for a fresh start of Bhushan Steel and recovery of its creditors. And then the matter went to NCLAT, wherein the judgment by the order by the NCLT was upheld. Fast forward to May 2nd, 2025, almost after 6 years, in a dramatic turn, the Supreme Court, acting on appeals filed by the former promoter and certain operational creditors, quashed JSW's resolution plan. This apex court found an entire spectrum of lacunas and flaws in the resolution plan of JSW with regard to non-compliance of mandatory requirements under IBC. It also criticized resolution professional, the committee of creditors, and even the NCLT and NCLAT for approving a plan that is deemed to be in flagrant violation of the code, particularly concerning delays in implementation and the mode of equity infusion. This complex and far-reaching judgment requires a meticulous examination. And to guide us through this labyrinth, we have three experts with us. Dr. Neeti Shikha. Ma'am is a lecturer at Bristol Law School and a former head of the Center of Insolvency and Bankruptcy at IICA. Dr. Shikha is renowned academic in insolvency law with policy experience advising in legal Indian government and contributing to global insolvency discourse. We have Dr. Charu Mathur. Ma'am is an advocate on record at the Supreme Court of India with over 25 years in commercial and constitutional litigation. Dr. Mathur brings a unique blend of legal practice and policy expertise to issues of corporate law and economic governance. Our third speaker is Mr. Akash Sherwal. Sir is a partner at Samvad Partners, specializing in insolvency and restructuring. Akash has advised on several high-stakes IBC matters and brings deep practical insight on how India's insolvency framework operates on the ground. So, starting with Dr. Charu, ma'am, what are the key legal issues and reasonings in this judgment?
Thank you, Ritima. So the first thing that these were 7 appeals which had come to Supreme Court, and these were 4 by the operational creditors, 2 by the government, and 1 by the promoter. Now, 1 by the government was one which it has not even filed the claim. Right? If you see that this Bhushan Steel was part of Dirty Dozen, so it started in 2017 and we are in 2025 when plan had been implemented. It is one of those, it should be the North Star of IBC, where you could see that actually there has been a resolution and it has been implemented, right? It became a profit-making entity. right? It became a subsidiary of JSW. Now, the reasoning that they have been going on is look at their resolution plan, it was not proper. Now, this reasoning should go only on the one reason that at one end, Supreme Court says that you should not interfere with the commercial wisdom of the committee of creditors, right? At the same time, you are saying that they have not infused equity, they are getting some sort of debt, and they are creating some sort of mechanism to get the amount. At the same time, they have infused 19,700 crore rupees at a go. In one go, they have infused in this. They did it in three tranches. First was for 100 crore. Then they said matter came to the Supreme Court, and it was again by some operational creditor saying that our claims have not been satisfied. At the same instance, they had taken the money which was given under the resolution plan. So this was as such wrong. Second thing, when they talk about the related party and how they are connecting Bhushan Steel with JSW, it is related to a coal block allocation, right? Now, this coal block, JSW, it bid independently. But when the government decided to allocate it, it allocated it to three parties as one consortium. It was not as if JSW wanted to be a partner or they were hand in glove beforehand. This is the government said that to the three party, to JSW, Bhushan, and to Jay Balaji, we are going to allot it as a one single consortium. So this is not really a related party, if you mean what is there. Then coming on to that, they started PMLA proceedings and ED confiscated around 4,000 crores of assets of Bhushan Steel. Then Supreme Court itself says, no, it is fine because of 32A, you take it back. Then if I can point out at the hearing that took place, it used to take place for 45 minutes, mostly on the Wednesdays of the last 3 or 4 months of the Wednesdays, from 2 to 2:45. Bench used to sit at around 2:15, 2 till 2:45. So half an hour they used to hear the matter. Then at 3 o'clock they had a separate bench. So this is not really that they need to interfere in it. There is no ground. Like the idea of law is to have a certainty. Right. So here, when the plan was implemented, it was executed. Now, today, you are saying you have opened a Pandora box. You are asking them to return the money. Now, do you think that they had to see each person, they will go that, okay, I give you 100 crores, I take this. There might be some people they have given 50 lakhs. There might be people who have given them 25,000. So it is a mammoth task that they have taken, and it is totally unnecessary exercise that Supreme Court has taken up. So I think this is a judgment which requires consideration even in these holidays, in the partial working days as we are calling now. So this matter was listed, there was an application. So they have said that we are not going in for the liquidation till the revision petition is filed. Review petition is filed. So, I mean, the court, they do not need to take permission from filing a review petition. It is their right and they can do it as a matter of right. So even if you look at the legal reasoning, there are people who are saying that this decision is sound in law, but looking at the practicality, it is incorrect. But I think this is not a decision very sound in law also. So this is my take on it.
This is, I think, one of the first arguments where somebody is coming up that it is not even fine in law. Okay, we'll move on to Dr. Neeti for close reasoning in the judgment and any precedent that you know of in this context.
Thank you, Ritima. When I look at the judgment, I try to look at experiences from other countries, and I couldn't find a single case where courts have, turned away and turned around a successful restructuring. There has been interference by the courts, objections by the courts and stakeholders before a structuring plan is approved. So at the stage of proposal, there are many cases like, I remember 2011, there was a case, Supreme Court of Ireland, it did not allow restructuring of one of the cases. It was a housing company and court did not allow. And also because one of the reasons, one of the objections raised at that point was that it unfairly prejudiced the creditor. So there were issues around fairness, and fairness and treatment of creditors, but that was at the time of restructuring, and not once the restructuring was approved. So that is one case I found, from Ireland. There was also a recent case, I think, to 2024 in Hong Kong, where courts have, again pushed allowed liquidation of a company, but again, it was not once this restructuring was approved. That was a case. It's China versus Evergrande Group, where court did not allow, even there was a successful restructuring, which was proposed, and the company went into liquidation. But we have to be very mindful of the cases that we see internationally. These are the cases where within the scope of law, there is, their objections could be raised, and the courts was very much within its power and remit to allow, to reject restructuring plan and allow for liquidation. My memory, if it serves me right, in past 18 years of my academic experience and learning, I have not found a single case where courts have done that. Dr. Charu has very well explained how the judgment is not correct in law and even economically. And my concern is larger. My concern is the way how world looks at India, and especially at the time and moment we are right now. We are writing our own growth story. We are about to, we have become one of the largest economy, fourth largest economy in the world. And what kind of message are we sending to our investors? We're sending a message that, there's no finality even with the final court of justice. So I understand that courts are not open to consider public policies outside their remit of consideration. But at the same time, being the court of finality, if the laws have to be read, it should be read in the strict sense of letters of law, and also in the light of the objectives that the law has established. And Akash and Charu will be right people to tell us from the practice perspective and how the statute reads. I don't think it was ever envisioned that courts should have that kind of power. And if you look at the very design of law, committee of creditors, their wisdom ought to prevail, and there's been plethora of judgments by the court. The court has, established that we will not interfere in the commercial wisdoms of COC. Now, here is a case where, on the alleged fraud, alleged non-compliance of law. My question is, what was courts doing before? Was it not possible for courts to do some course correction if it was needed, rather than pushing an entity which was successful, which was revived, which had given employment to so many people? It had it had a role to play, not just in the steel market, but even otherwise, looking at the larger stakeholders' concern in mind. So that is my initial thoughts on the case.
Ma'am, I have a small question here. So, IBC was designed for time-bound resolution. This judgment highlights a tension between the need for speedy resolution and the absolute adherence to procedural compliance. So, where do we draw a balance here? Also, Charu ma'am and Akash, if you could pitch in.
So if I can just open one, and give some comments. There was a research solicited by the Insolvency and Bankruptcy Board, which I did during my tenure at ISEA, which was a policy think tank for the Ministry of Corporate Affairs. And in my research, we found that there has been considerable delays. So having said that, is delay the only reason why we are worried about it, is a question that we need to ask. Every cases are going through delays, and delays are not just happening because the system is wrong or the law is wrong. We found in a research that delay is happening because we have a structural problem with IBC. Let's put it that way. For instance, when we were doing surveys with IPs, we found that, the information memorandum that's prepared does not have all full information. Also, I remember we found out there is no market for stressed asset at that time. And we had recommended in our research that government should think about to build up a platform for stressed assets, which I think is now, is something that we are moving towards. So the problem we are facing a structural problem. Delay is there, but it's not something which is only owed to the parties. There's also structural issues. There are some teething issues we had. And despite all that, the successful cases which has happened, and now we take a judgment of this nature, we give a judgment of this nature. We took 10 steps forward. Now we've taken 100 steps backward. So those are my initial comments, and over to the practitioners who will give better insight.
Yeah.
Yeah,
So
thanks, Neeti. Now, there are two things I guess I would like to state a bit differently from what has been said for me. Now, in terms of, there are two aspects this judgment deals with. One is the procedural compliance under the IBC, as laid down in terms of the timelines that are mentioned within the IBC. And second is the efforts or actions of the parties involved in these proceedings. When these are the two as broad aspects, if we need to divide, what is that made the court believe that this is a plan that needs to be set aside. On the procedural aspects, there were issues on delay in completing the process of the seeking the approval of the resolution plan from the NCLT itself. Section 12 of the IBC prescribes a period of 180 days, which is extendable by 90 days. So you are looking at 270 days to complete the process where insolvency starts, and you have a resolution plan with the NCLT. Of course, there is an outer limit of 330 days as well, but I'm not getting into that right away. So this matter, I believe, started in 2018, if not late 17. These were the early days of IBC. A lot of tribunals, IPs, and practitioners were still figuring out what is the strictness associated with these timelines. And if you look in the present case itself, the 270 days limits has been widely violated, not just slightly. And there was no efforts by the IP to seek any extension beyond the 180 days itself. I think the Supreme Court takes a note that there was almost a 4-month gap between the approval of the plan by the COC and filing the application with NCLT. So these were certain procedural aspects which irked the Supreme Court. And to be honest, we have come a long way already, practically speaking, in resolutions and at IBC. Now we see tribunals and IPs being more strict and disciplined when it comes to following these timelines. On the substantive aspect, there was, I believe, the most important issue. Of course, there were multiple issues which have been referred to by Charu and Neeti already. But the implementation, the delay in the implementation of the resolution plan by the successful resolution applicant, JSW, was what was really playing on in the court's mind, as visible from the judgment. Now, this is a plan which has been approved. It requires a payment of 19,000 plus crores. It requires a separate payment to operational creditors, which I believe was to be made within 30 days. So the judgment mentions 30 days as the effective date, but I believe the payment to the financial creditors was made at 400 days plus after the approval of the resolution plan, and to operational creditors at a significant time after that. And this entire period, there was no stay on the implementation of the resolution plan. So JSW was filing applications and appeals, trying to seek clarification on the implementations. And the court saw this as a process of using the legal proceedings to delay the implementation till it suited JSW better. Now, these are the observations made in the court's judgment. I'm not subscribing to them. I'm just putting out and what are the two axes that the Supreme Court looked at. Now, so when you see this entire plan being set aside, you're looking at procedural defects which have been separately held to be are required to be followed by Supreme Court judgments. For instance, the non-modification of the resolution plan. So the extension of the resolution plan period could be a potential modification of the resolution plan, which the Supreme Court has separately held is not permitted. And secondly, non-implementation itself was something which I guess ultimately led to the plan being set aside. So this is my broad view. I don't want to go on, but I just wanted to highlight that procedurally, there are two aspects on the procedural access as well as the parties' conduct, which led to this, decision, which practically creates many difficulties. But I guess we are all aware, Supreme Court has a long history of not being held back by practical difficulties sometimes, but more in ensuring that the letter of the law is followed and is also serves as a beacon for everyone else to follow as well.
I have a collective question for everybody. So, now that we have delved into the reasoning, what did Supreme Court say, why did it say, and briefly on the implications part of it, including investor sentiments, what could be the policy and economic reflection from this judgment? We can start with you, Akash.
Thank you. So I think, like I said earlier, the procedural compliance in terms of timelines following affidavits under 29A to 29A for anyone who's listening in is a affidavit that is to be given by a resolution applicant to demonstrate that they are not related to the corporate debtor in a manner which is not permissible under law. So these are procedural aspects which have already been now to a most extent, I can say, based on my experience, being followed by tribunals as well as RPs as well as resolution applicants. I guess the two main aspects, as per me, which flow out. One is the discipline that is required in implementing the resolution plans. Unfortunately, there is no clear data that at least I'm aware of, that after resolution plans are approved, to what extent they are implemented and what are the timelines for their implementation. I think IBC, in its wisdom, rightly so, did not choose to regulate that aspect because there would be many manners and many facets to implementation of resolution plans. But as a practitioner, I've often come across queries where plans have been passed, 2 years ago, 3 years ago, and they're still to be implemented. Whereas the initial timelines under those plans were of a much shorter nature. I think it's one of the aspects of policies of IBC was to ensure revival of corporate debtors, because it is not just a commercial action. It's an action which can lead to employment growth. It can lead to revitalizing, the microeconomy or the region where the corporate debtor is. So I think that's one aspect that the Supreme Court has noted, that tribunals should be mindful of ensuring timely implementation of resolution plans. They should be a little more wary, if not disciplined, about accepting applications for extension of resolution plans time periods. There are other legal aspects on whether those amount to modification or not, but I don't want to get into that right now. And the second aspect, as per me, which is the aspect of PMLA and attachment of assets under the resolution, under the CIRP process. So Section 32A, provides that corporate debtors' assets will be, in a general sense, available for resolution. Any criminal actions against the corporate debtor and promoters will not, bog down the resolution process. The court has reiterated, and I use the word reiterate because it's not something, a new law that has been laid down, that NCLT and NCLAT should be wary of interfering in any orders passed by the adjudicating authority or any attachment by the enforcement directorate. The relief for that lies in those respective appellate procedures and the PMLA. I think we have been seeing some orders by NCLT and NCLAT on this issue in the last few years. We'll have to relook on how to approach that issue.
Right. So if I can just share. So first thing is that you see this appeal came to Supreme Court, this SLP came to Supreme Court in 2019. It became appeal in 20, but rather it came as an SLP was also there and appeal was there. So Supreme Court itself kept with it for 5 years before deciding the matter. Second thing, when you have do anything, like I always say, and Supreme Court has been saying that there has to be an what is the impact of a judicial decision, right? So even if you look at the Fitch rating today, nothing has gone wrong on JSW. It is still the number one steel maker here. Its credit rating has not gone down. What has gone down internationally is our trustworthiness in the system, right? There is no certainty in the system that today, okay, resolution plan has been passed, it has been implemented, Bhushan has become the subsidiary of JSW. But again, you can go to the court and some small operational creditor went. First of all, Supreme Court, following his previous judgment, should not have interfered in it, right? And second thing, they said that COC comes and say on March 2020 that if the appeal is allowed, I am going to return the money. Then that money is to be put into the escrow account. That effectively means that nobody is getting paid. That is not the objective of the IBC. Right, so objective of IBC is being defeated by these some kind of thing. There is no consistency in the decisions that are coming from the Supreme Court. Either you allow for everyone, and this is a case where they have started making profit. I think 650 crores was the last profit in the last year that they made. So, I mean, this is absolutely, I don't want to use atrocious, but I'm very, very disheartened with this judgment, to say the least. And there should always be audit of what is the impact of the judicial decision, right? When we talk about ease of doing business, where do we stand? IBC has this one single legislation which has helped India climb many, many rungs in the ease of doing business. But now with this one decision, I mean, we are nowhere. Right, there is no certainty, and I think this is becoming a habit with the Supreme Court, even when it has the good intention. Like if you look at the arbitration judgment, that when can it be modified, or the earlier 1-7 decision, when did they open? That decision was decided 10 years back. Because you want to set some law, so you collect a 7-judge bench and give a decision to undo NN Global 5 judgment. So I mean, this is not a practice of, this should not be the practice of any constitutional court. And if I can just quote the assumption from UK, he says that courts are just supposed to decide. You are not there to do everything. This is a limited realm. This is the law. You have to interpret it. So, so this is just my take on it.
Ritima, thank you, Charu and Akash. You really put forward, contrasting consideration that court had. Whenever I see a judgment like that, I'm reminded of Salmon versus Salmon, a classical case from, I think, all the company law lectures starts. And I remember, that there was a time when Salmon was highly criticized. And but the fact that House of Lords were aware that in the early days of limited liability companies' existence, if they had given a judgment otherwise, I mean, that was a case where there was apparent fraud. People knew Salmon is abusing the corporation as a vehicle of commerce. But House of Lords, they tried to stick to the letters of law, did not read into the provision and said, no, Salmon is separate from its company. Now, why I'm trying to say this here is that there are two things courts need to, all the judges and courts across the globe need to learn from Salmon. First thing is, at the highest court of law, your role is limited to interpret and read letters of law, right? And second is, sometimes you have to read the law, even if there might be underlying fraud at the helm, because it is important for the growth and trust in that piece of legislation. Now, with IBC, Akash rightly pointed out where the delays have been. There have been non-compliance. My question is, it is a part of monitoring and evaluation of a plan that ought to happen. Do we have a system in India where once a restructuring plan is approved by the courts, parties come together and there is a monitoring and evaluation of that restructuring plan or proposal that has been passed? The answer is no. So probably it was left to the wisdom of the parties to, agree to that and to talk it out how they wish to sort of go ahead with it. Now, burden of absence of M&E, which is not there in a plan, probably we didn't expect that time that we had to come up with that, should not be lying with the parties, especially at the disinterest of them. So that's one point I want to make here, is that even if there was delay, or there was, it would took longer to implement proposal, if the parties were okay with it, court, courts, let alone courts, nobody should have bothered about it, because ultimately these are contracts, and the very premise of contract is consensus ad idem. Parties have agreed to it, let them go. And we should not interfere unless there's a, public interest, at the core of that issue. Now, if you look at the problem here, what was the public interest that court was trying to take care of? The answer is all these issues weighed in favor of Bhushan, which was a revived company. Now, second thing I want to, point out here is that, as Charu rightly said, that insolvency and bankruptcy code was a visionary law in India. I know some of the scholars have argued that, it was not an economically viable judgment. Now, it was a visionary law that dealt with a case where company had reached making profit. It should have not been open to the courts to apply their own, indigenous standard, if I can call them, of, compliances. I'm reminded of the Renu Sagar judgment. When I was a law student, studying in London, and this judgment came, India was criticized across the globe for what the Supreme Court did at that time. Look at Vodafone judgment, retrospective. Now, these judgments do not have an impact only on the parties. That is one thing, fundamental thing, which I think judiciary ought to understand, that these have repercussions beyond the parties. It has repercussion on how India is seen as destination of, investment, destination of, commercial litigation. And I'm sorry to say that this has really made our countries walk multiple steps backward. And the conversation can go on whether it was legally sound or not sound. My 2 cents is that this was not an issue where court should have stepped in. Non-compliance at this stage, I think it's a failure of justice if the non-compliance is being looked at this stage after so many years. Second thing I want to say is that looking at the role operational creditors are playing in IBC, I'm a little wary of that. I still remember, I was vocally dissenting to them be given voting rights in COC, because that defeats the very, the jurisprudence of insolvency. Courts took many years to come to conclusion they can't vote in COC. So what I'm trying to say, that insolvency is not to do equity or justice. It is to basically do its purpose, wealth maximization, turning around the company. And if that has happened, and if there's structural delays happening because of not just one party, because multiple things, court had to stop reading too much into it, should stick to the letters of law, and it should not be open to the... Now, who could have challenged? Probably the parties could have negotiated themselves. This was a case, probably Akash and Charu can tell me, if there was a delay in payment, parties could have come to, renegotiation. I think mediation that we are looking at, and also we're trying to marry it within the IBC, this is something could have been explored. Court would have said, fine, parties, go outside the courtroom and try to see if you can come to a settlement. And because people would have consented for that through negotiation or mediation, they would have probably reached to a better conclusion than what we have today.
On this point, Neeti, I think I would like to add something here, which would, is relevant here. So the structure as under the IBC today, once a resolution plan has been submitted, now I recall we are only allowed one amendment. And once it has been approved by COC, then it is set in stone. Now, after that, once it is submitted to NCLT for approval, no further changes are permitted. In fact, even NCLT is not permitted to make any further changes in the plan. So as it is submitted to as it is approved by the COC, it needs to stick to that letter. It needs to stick to those provisions. Now, there are reasons for that as well. There is a aspect of procedural fairness, because when multiple resolution applicants are bidding to submit their plans, sometimes the matrix in which they are determined inter se, that depends on what conditions of plan they have proposed. Now, tomorrow, if you relax those provisions, you are basically allowing someone to have the upper hand without having proposed competitively a similar structure at the point when you were determining who would be the successful resolution applicant. And the second thing is, you're right in terms of the difficulties you highlight. Those are issues that are going to crop up today and tomorrow as well. Because implementing a resolution plan has many facets to it, not just financial, which is payment, but it involves sometimes just payment of electricity dues, getting a license to mine minerals. There are many types of corporate debtors who are involved in the process, and allowing some flexibility within the resolution plans after their approval would permit things like mediation, as well as ensuring revival even at the cost of delay sometimes. So I think that's a structural call that policymakers have to decide to what extent can we permit that flexibility, because as of now it is not permitted within IBC or as per the judicial precedents that we have.
So I agree with Akash on this point that this is what we really require, and I think Neeti can push that further to IBBI and everyone. So even in this case, like resolution plan should be accepted as it is. It can be accepted or rejected. It cannot be conditional, which in this case it was. So to that extent, it was right. But looking at the amount of the money that was involved in this particular case, so probably they had to make certain adjustments. So even when in the NCLT judgment they give that these are the conditions which should be fulfilled, so that amount of little bit of flexibility is required. So there has to be gray areas. It cannot be yes or no for the resolution plan, because there are actually practical difficulties that the parties encounter.
Yeah. And I think my point there would be that, the plan is like a proposal or contract. So basic principles of contract, terms that goes to, that hits the core of the contract. For example, how much money is to be paid it could be seen as a term, violation of which could be violation of the plan. But, things that don't go to the core or heart of contract, like payment terms, when money has to be given, that cannot be the core of contract. That could be term, and breach of that or violation of that could not be seen as a violation of the, of the restructuring plan. So the point I'm trying to make here that, if pragmatism has to follow, it should follow to 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 interpret the law, taking, cues and nuances from other field in the spirit to fulfill the objective of the act. I mean, nothing stops the court to say that, okay, this is an agreement, the term has been breached, and it is difficult to sort of, go ahead with the term. But at the same time, payment timeline. And the timeline of payment is not contingent only on the parties. I think also the problem, I feel, one thing that really is affecting the market is that we always move on the presumption of distrust. Of course, because there are many bad apples, and that has really, got a bad name for the market. So today when I talk to anybody about IBC, they say, oh, it's become a money-making mechanism, right? Because they're bad apples. And then you want to set the tone right. But one has to be very mindful as to what is role of legislation. Judiciary can't do it. Role of judiciary, legislators can't do it. And in commercial laws, we cannot have a law which can, as Charu rightly said, can determine black or white. There'll always be shades of gray. And there the judiciary has to show pragmatism and step up, and say, okay, what needs to be done? Now, if there were people who are doing fraud, company is a separate legal entity. Company should not be punished. The person should be punished. So I think we need to sort of really redo our homework in a sense, all of us as a stakeholder, as to should exceptions make the law? Should exceptions move the law? Now, one case like Bhushan, I wouldn't be surprised that there'll be swarms of litigation now coming to Supreme Court challenging all the old plans, right? So I think as a judiciary, as a lawyers, we have a larger role to play. And it's not philosophical. It's something which the very law, it is a cardinal principle of law that you have to put an end to litigation. And if courts keep those larger principles in mind, courts are not just justice. They do deliver justice, But justice in a commercial sense is different from justice seen in a civil sense. So looking at the role of operational creditors, looking at how much challenge they could bring into the court, and all this is something which needs to be settled in. If we don't settle on this matter, my serious doubt is that we'll really losing the trust of people and the market in the process, so I think there has to be some modifications done, and maybe as a collective we could think about what could be done. One thing that has come out is monitoring and evaluation of the resolution plan, especially with the plan proposes there'll be a payment over time. At the same time, this is an executive problem. Should courts really look into? So these are the questions I think all of us have to sit and ask ourselves.
Yeah, and there's another point, Neeti, that you mentioned. I want to address that also in terms of Supreme Court interfering with the commercial wisdom in this case. I think the Supreme Court has not um, challenged or attacked the approval process of the resolution plan by the COC, even though there were certain defects in the timeline there. They were more concerned about the acceptance of payments by the COC 2 years later after the approval of the process. And of course, there is some discussion within the judgment about the commercial wisdom as well. But that has only been to the extent that the COC should have been mindful of the spirit of implementation of the resolution plan rather than deciding what is the haircut that you need to have in this case. So usually I'm only mentioning this because when you talk about commercial wisdom, you are usually talking about how much money has COC accepted. Against the dollar, have you accepted 1 cent? How can you do that? So that's what courts have held in the past. So it's a small point, but I wanted to, just elaborate on that a bit.
Yeah, I'm also now, you made me think about, the very premise of commercial wisdom. Should it be limited to just the value, or should it be a larger concern? Today's time when we're talking about corporations, who have a role. I mean, they may have a role to play, in society at large. One corporation bank, for instance, may be moved by stakeholders' concerns higher than other banks. So the point I'm just thinking through, and maybe Charu, you could help me think through this, is that should commercial wisdom only be limited to the financial wisdom, or is commercial wisdom larger than financial wisdom? I think we need to draw a distinction between financial wisdom and commercial wisdom, and you can't separate. You can't take out commercial. You can't say that they don't have economic or commercial wisdom. It only is limited to the financial wisdom, because if the collective decides to take more haircut and revive a company, so be it. If the company decides to liquidate, so be it. So I think the very premise of commercial wisdom should not be seen in a very myopic sense. It should be seen in a larger sense. And the decision that flows from it should be left to the creditors, the committee of creditors.
Right. So I agree with you, Dr. Neeti, there. So the first point you are talking about, the commercial wisdom as we taken today, it is essentially the financial wisdom of the essentially the banks who sit in the committee of creditors. I appear for some of the government department also, and I always feel a pinch, or for the Industrial Development Corporation where they are into public-private partnership. So the lease right goes to the successful resolution professional without getting any income for those corporation, the government corporation which are there, or they are taken as operational creditors. And if you look at the value of land, in many cases, it is only the value of that land that they are having, the lease holder that they are there. That is the only asset that they are having. And the one who should have a say in that person is taken out. So you are actually throwing the people who have the actual stake in the matter out of the consideration. So commercial wisdom of committee of creditor, it needs to be flexible. It needs to be understood, particularly in the cases like where these Industrial Development Corporation across the country, when they give lands on lease to the various companies, and then they go into debt and becomes corporate debtor. Now, when the decision is to be taken by the committee of creditors, it is only the banks who take. And if you look, actually, the only asset that they are having is the lease right. Now, this lease right, you said that it is again, and it can be transferred for the remaining period. But today, if this person again auctions that lease right, right, they are going to make a lot of money out of this. So I think commercial wisdom, I think they need to think vis-a-vis this particular aspect. And today, what we see is only the financial wisdom. It is not the commercial wisdom. When you are talking about the commercial wisdom, I think party autonomy has to be given some respect, some leeway should be provided to them. As Dr. Neeti rightly said, that if they want to liquidate, they want to liquidate. It is up to them what they want. I mean, you don't have to make every case a PIL case, even in the commercial case, that you have to give a long decision that this should be done. You don't have to do moral preaching here, anything. You have to decide by the law, this is a private law, right? You don't have to get any element of public law into this.
Uh, like, does this bring us to a question of reevaluating the overall institutional or procedural framework for IBC?
It does, according to me. So even if you look Vidarbha or Rainbow, these decisions which have come, or even the Bhushan Steel, so it is not that court is entirely wrong, but because it is a private law, this is within the ambit of the contract which was there, or in this case, the RBI identified the dirty dozens, and so you are going to do it. But there need to be little relook, and they should be mindful of timelines. Timelines should not be illusory. Practically speaking, 1 week timeline to remove the defect, it is impossible to do certain things. If I file an IA against some order, so the matter is stuck in the court for long, then you deduct that much period from the actual period. So this is all unnecessarily. Give some realistic timeline in which people can actually come and resolve the issue. So if the intent is clear that we actually want to resolve the issue, if idea is not to do recovery, if the idea is not to put some companies into insolvency so that you can favor X, Y, or Z company. It has happened in many cases. Like if I talk to you about JP, it has the prime land, right? Today, the most valuable stretch of the country is Greater Noida to Agra, the entire expressway that is there. It was doing fine. Ultimately, even if today you have given it to NBCC, it will also subcontract to the same people who are going to construct it. And then you have to look into the context why they have become a bad company, right? Or bad debt company. Like in the JP's case, because of NGT's order, it unmindfully said during the CWG that you cannot have construction within the 10-kilometer area radius. So 10-kilometer radius for a city like Delhi, it will cover the entire periphery of Delhi. So the inventory that is there of all the real estate company, it was because of that order. How can you blame them? That is why judicial impact analysis is very important.
Any thoughts, Dr. Neeti?
Uh, I don't know. I mean, honestly, this is a question that I keep asking myself, especially being so emotional about IBC. I'm not sure if you make changes and then there'll not be a problem in future. I think a good law is not written only in the books, it's written in courts. So I think what we need more is education of stakeholders, including the judges. One thing I strongly believe, which Professor Rebecca Parry and I have worked in past and written about in past, is that probably IBC is like a one size fit all solution, which probably it can't be. And we have been propagating for sectoral approach to insolvency, which means the real estate companies' insolvency needs to be seen separately. Like in the UK, companies which are of public interest, they're seen separately. The way you handle them, the way the jurisprudence has evolved in those companies, for example, energy companies, electricity supply companies, water companies, these are seen, and the jurisprudence and wisdom in dealing with those cases is separate from what you'd see other corporations. So I'm not sure if we really need to rewrite IBC. Probably what would be interesting is to think about a sectoral approach to to different companies that we're looking at. And because when I did my research for IBBI, it was not that most of the companies were facing a problem of delay. The delay was more in real estate highest in real estate companies. In in software companies there was not much delay. So what we need to sort of look into is that not using like a paracetamol for all the problems or all the pains that we have. We need to have a root cause analysis and see which companies has those peculiarities and weaving those into the law. Now, one issue that may face is it means we have several laws to look at, and that's maybe very burdensome. So, and here I think practitioners can help me think through if we are really looking at a pragmatic piece of law, maybe there could be sectoral regulation that applies along with. So you have IBC, and then you have regulation that could sort of guide that sector. Now, see, real estate problem is such a big problem in India. And in the UK, the law is so clear. The homeowners do not start paying the mortgage till the house is finished. And they have not made a new law for that. The commonsensical principle that contract can only conclude when the subject matter is into existence. I mean, we used to teach 20 years ago in the classroom that subject matter ought to be in existence for the contract to come through, right? Or it is only an agreement to sell. Now, here what happens is the mortgage does not start when there's an agreement to sell. Mortgage only starts when the product is finished and the titles are exchanged. Now, whatever money is given is put in an escrow account. It does not go to the real estate developer. So what I'm thinking is that maybe we need to have this kind of pragmatic and practical solutions. I mean, it does not really need a tweaking of IBC. It may be needing a regulation for the real estate market, that this is what you ought to do. Have an escrow account, money lies with lawyers or escrow, wherever it may be. And then you can really do away with the woes of homeowners where they have been started paying on the mortgage from the day they have got this agreement to sale and the project has not been completed. So maybe some percentage could be paid and rest that to an escrow. Likewise for electricity industries, electricity sector. So yeah, I think we need to look at sectorally what the problem is and maybe come up with the regulations, which could be at a department or a ministerial level. And of course, IBCs can be cured not only through legislative action. Maybe judiciary can, follow a set pathway. They could. What is the problem is that there's a lot of scaffolding that's happening, which is taking us into different tangents. We just need to have a set approach. There has to be predictability. Let it put it that way. There has to be more predictability of the outcome.
So Neeti, I just added one more thing here. So recently, Supreme Court has gone into this banker and builder nexus. So they have gone into CBI inquiry for the same because all these payments are construction linked payments. So whenever first floor is done, you make X amount of payment. Second floor is done, you put X amount of payment. But what they do, they make the entire amount of payment. They don't do anything. They start another project. So the court has ordered a CBI inquiry into builder buyer nexus. So right now, all the buyers, at least in NCR, are getting called from CBI. That much I know. So it will be, hopefully it should lead to some resolution somewhere. But again, a difficult task for a country like us. I think Akash will agree with that.
Yeah. My thoughts, Ritima, on your question about tweak. In a sense, whether we need to tweak with IBC on the basis of the this judgment. So, like I said earlier, I think there are 2 or 3 areas that this judgment has shown that are problems within the implementation of the IBC framework. One, whether we allow any modifications to the plan after it's approved in view of the time it takes for adjudication of the plan and any appeals against the plan. That's one aspect. And something that's related to that is what happens to the corporate debtor during this process. Like I believe it was mentioned earlier that JSW, Bhushan Steel, was being run throughout this period of 5 to 6 years when parties were fighting over who should get the money and when it should be given. And it actually turned out to be a profitable entity. I'm taking what was said earlier. I don't know that personally. So a corporation has been revived while people are still fighting over it. I think IBC to that extent achieved its goal. It took away the elements which were causing it to be a loss-making entity. But this is a common problem. This is not unique to this entity. There are many corporations, functional, undergoing insolvency, and maybe serving some purpose in the interim. Like I have personally dealt with the insolvency of a major power plant in Punjab. So running RPs who are tasked with running corporations, say for 180 days or 270 days, suddenly become the board of directors, MD and CEO of power plants and steel companies. I don't think that's a skill that they had, or it's a task that they thought that they would have to undertake. So sorry, coming back to the point, I think there should be some thought process about dealing with the interim period between the approval of the plan and attaining finality of the process. I can't, of course, I would love it if that could happen back to back, but I know the Indian judicial system and courts, that's a wider debate in terms of whether we can achieve it, in a expeditious manner. Although having said that, I am in tribunals and courts every day. I see judges trying very hard to kind of achieve these timelines, in view of the enormous amount of pressure that they have. So it's, I think, more of a structural problem than a stakeholder problem alone. I think the second aspect, in terms of tweaking an IBC if required, is to probably have a more detailed mechanism. I'll say right now there is an aspect which allows the tribunal to ensure that there are provisions of the plan which ensure its implementation. Maybe we can take a step further. Probably first there could be a study on it. I'm not aware if anything has been done till now, and see if something can be introduced to allow for better monitoring and better support. I'm not seeing this only as a stick approach that you implement it, otherwise we're going to smash you with it. Probably allow support from the tribunals, from the other stakeholders, to allow for expeditious implementation. Maybe identify the common problems as well in that process. That's all.
Okay.
Thank you.
I think we'll wind up here, and I feel it was very engaging and discussion when it came to Supreme Court adjudicating on commercial wisdom of COC to some extent, or drawing the balance between speed and compliance. There are more questions that are coming up, but I'll just stick to the timeline we have in mind. More questions related to capacity building for NCLT and CLAT. Role of RPs in this whole process. But thank you so much. Thank you to all the speakers for your time and for sharing your knowledge with us.